All rise. The Honorable Vince Babauta is in session. Are we all set? The live stream, okay. Let me go find the marshal.
It's 10:30 to start.
Yes. Do you know if media is coming in? If not, if we do like a group photo, Judge Mona just asked if she could be included like a group photo for her stuff.
No. Hello? Hello? Both? Hello? Hello? I'm never off. That's okay. I just moved my mic up so you guys don't hear me. No, we're gonna close it when we start.
Mic check. Mic check.
Okay, I can keep it open for you. Oh, your way your keypad works? I cannot, if we close it halfway, I think it beeps. I think it beeps if we, just leave it open? Okay. Everybody turns? Okay. Oh. Summary? But that's okay. And we can turn it off or we can actually just put on for the championship.
Okay.
Doesn't too much.
I don't know.
Okay. We'll just
I think
unplug
we
it.
just turn it off.
Yeah. Just do it on that. What's the password for this?
Hello? Hello? Testing. Is it good? Closer. I think I might put it on the side then. Hello? Does it sound good? Testing? Is that closer? Wait, can I actually? Oh.
Maybe
Keep the wire
like that.
Actually, if we can have something, or let's see. Testing, testing. 1, 2. You good? Does this sound good? Can you like stand in the back and tell me how it's, or are you allowed to like, or maybe stand in front and tell me how it sounds? Does it sound okay? This one? Okay. But this wire, I want to get this thing out of the way.
Honorable Justices,
Hello, hello? Honorable Justices, maybe you gotta lean over a little bit. If it's...
does that mean I got taller? Here, try that. Honorable Justices, yes. Miss Judy, how does it sound? Like, is it clear? Okay, I think we're good. Hello? Pa, 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 pa. Ah.
Testing.
Did you fill this out already? Oh no, then I need you to fill this one out. I'll just, yeah. I'll just, yeah. How about Jan? Which is, yep, that's your short, I mean, you're giving up an extra minute. You only give somebody an extra minute? Honorable Ramona V. Mangloña, Associate Justice, the Honorable John A. Mangloña, Chief Justice, and the Honorable Perry B. Inos, Associate Justice, presiding.
Please be seated.
Before this honorable court, Your Honor, is appeal number 2024 SCC 0130 CIB, Sabrina Katpinteru versus BBI Regional Aerial Transport.
Buenos dias. Good morning, everyone. Good morning, appellants and appellee. It's nice to see you here in the final rounds. But first of all, as introduced, we have Justice Barry Inos to my right, and we thank Chief Judge Ramona Mangloña from the U.S. District Court for assisting in this final rounds of the moot court competition. Anyway, let's have the attorneys introduce themselves. Okay, Vince, can you please make sure that the microphone is on and so we can hear it?
There it is.
Good morning, Your Honors. My name is Judith Ross-Nickdow, and I will be on the appellant.
Okay, welcome. And for the appellee,
Good morning, Your Honors. My name is Carly Kate Dela Cruz, and I am representing appellee BRAT Air.
okay, good morning. So is the appellant ready for the arguments? All right, please, you may approach the lectern.
Chief Justice Mangloña, Honorable Justices, may it please the court. My name is Julia Lynn Taitano, and I, along with my co-counsel, Gia Ross-Nickdow, represent appellant Sabrina Katpinteru. I will address the first issue regarding religious accommodations, and my co-counsel will speak on the second issue concerning the non-compete clause. We would like to reserve 2 minutes for rebuttal. Your Honors, this is a disheartening case about a company that prioritized its comforts and convenience over its most valuable employees' family and faith. As such, we request the CNMI Supreme Court to reverse for 3 reasons. First, of the 2 tests, the Superior Court applied the de minimis test. However, due to occupational contrasts in Beetle, we request to use the substantial increased cost test. Second, under the substantial increased cost test, BRAT Air violated Serena by denying Sabrina of reasonable accommodation. And third, even if the de minimis test is applied, BRAT Air still violated Serena by failing to show undue hardship.
Counsel, what is the trial court, the district court's reasoning for granting the motion for summary judgment? What specific conclusion did it arrive at, legal conclusion?
Your Honor, to answer your question, I would like to compare this case to Beetle, where they utilized the de minimis test on the grounds of public safety. The Superior Court used Beetle and compared it with the public safety in Beetle. However, we request the court to apply the substantial increased cost test due to factual distinctions. The police
But
department.
what was the Beal decision? And what was that one sentence? It's kind of conclusory for the trial court to just mention its reasoning with just one sentence. What was it?
The Superior Court ruled against Sabrina because first BRAT Air did not violate. The Superior Court found that BRAT Air did not violate Serena, and second, the Superior Court found that the non-compete clause was enforceable. We would request the court to utilize the substantial increased cost test.
Counselor, before you get to the standard, what law are we looking at here? What discrimination law? The federal discrimination law under Title VII or Serena?
Your Honor, we're looking both at Title VII and Serena.
Well, the cause of action is under Serena, right?
Yes, Your
So
Honor.
what is the Serena law?
Serena is the Commonwealth law, and thus federal law doesn't exactly apply
What
to.
does the law say?
Serena states that employers must not discriminate against an employee's religion. And though federal law is not binding on our Supreme Court, because the Superior Court, because we have not had any cases beforehand determining which test to use, we should still look at federal law for precedent.
Well, counsel, wouldn't you agree that the body of law in this area regarding religious accommodation is under the de minimis test for the past how many decades? Why would you argue that we should apply the more challenging reasonable accommodation test or
Justice Ma-
undue hardship?
Justice Mangloña, that is a great question. The 2023 recent 2023 case of Groff limited the de minimis test to a seniority system, which is not present in Sabrina's case. In fact, the U.S. Supreme Court in that case identified numerous instances where an employee would suffer hardship at the minimal or sometimes non-existent expense of an employer. For example, under the de minimis test, terminating a Muslim woman based on her religion would be reasonable because the negative stereotypes surrounding the religion would hurt
But in
business.
this case, we're not dealing with seniority, right?
Your Honor, I'm sorry, may you repeat that
So
question?
you mentioned that the 1977 case, the minimus case, it involves seniority?
Yes, Your Honor, it does. But Sabrina's case does not have seniority. And
Correct. Go ahead.
additional,
I want to get back to your Beal case. What was the Beal case about?
in the Beetle case, the police department had emphasized team-based training. Their schedule was busy, risky, and sporadic in comparison to Sabrina's occupation as a solo commercial
But
pilot.
what decision did the court arrive at in Beal? They used the magic words. What were those magic words?
Your Honor, in the Beetle case, they ruled against the employee because the police department required employees to be available almost
Public
at any
health and
possible-
safety.
Yes, Your
Public
Honor.
health and safety, right?
Yes, Your Honor.
Okay, so how does that differ, or how is it similar to this situation? Is there really public health and safety? That was the one-liner that the trial court used, right?
Yes, Your Honor.
Because of public health and safety, we're going to grant summary judgment. So how is, in Beal, it was the police department, but here it's a commercial airline industry.
Yes, Your Honor. Because of the differences, the factual differences, we should apply the substantial increased cost test. Sabrina has a set schedule to fly 3 times a week, and being called to service abruptly is just part of the job as an officer. Additionally, Sabrina's accommodation requests don't interfere with her actual work since her accommodations cover the missing days she would have.
Well, counsel, in this instance, didn't your client give the company a mere, 3 days notice or 2 days at most? Isn't that unreasonable to force the company to pursue a substantial increased cost to accommodate in that short time?
Not necessarily, Justice Mangloña. As shown in Justice Marshall's dissent in TWA, Brown, and Cooper, the employer must at least show an effort in accommodation. BRAT Air failed to even attempt in communicating with either Troy Sablon or Post Alone. Under the substantial increased cost test, Groff states that simply rejecting employees' suggested accommodations is not an undue hardship.
But isn't
Okay.
it true, counsel, that your client acknowledged that the company already looked into it, and if the accommodation as suggested by your client was in fact followed, they would lose all the profit for those Saturday travel?
Not exactly. As shown in Sabrina's deposition, BRAT Air failed to communicate with Post Alone and Troy Sablon, which is where they would know
But
that.
counsel, how could that be? The letter of accommodations was sent on April 11. She didn't work 2 days later on a Saturday, and then, and she was given notice at that Saturday meeting, and if you don't show up, or maybe prior to Saturday meeting, if you don't show up, then we're going to terminate you. But it was on a Monday, April 15, when the letter of termination from BRAT came, right? So do you think there was sufficient timing there for BRAT and the executives to look at other accommodations like contact, whoever, Mr. Sablon or Post Alone, if Sunday or Friday flights will be okay? There wasn't enough time. Sabrina just didn't show up for work 2 days later after she submitted her request letter?
Your Honor, we respond to that by looking at the facts stipulated in the cases. BRAT Air didn't attempt to communicate them and communicate with the other parties, and maybe if they did, they would have gotten a response. Regardless, their effort must be shown. An effort has to be present, and BRAT Air failed to show this. In fact, in Billy's own words in Sabrina's deposition of Exhibit C, quotes, "The impracticality would cause the company to not make profits on Saturdays." There's no facts backing up these are assumptions with no evidence backing up her words. Even if the de minimis cost test is applied, the case should be reversed because BRAT failed to show undue hardship. In Philbrook, the case was remanded because the lower court failed to determine undue hardship of an accommodation request. Similarly, the Superior Court
What
failed.
are the factors that we look at for these substantial increased cost according to Groff? What do we look at, that the corporation or the employer has to do?
Your Honor, in Groff, Justice Alito specifically indicates that, quote, "coordination with nearby stations with a broader set of employees," end quote, "could be a reasonable accommodation." BRAT Air not only failed to consider other possible accommodations. Your Honor, I see my time has elapsed. May I briefly answer this question?
Yes.
This means that BRAT Air not only failed to consider other possible accommodations as required under Groff, but they also outright rejected an accommodation that the Supreme Court specifically recognized as reasonable. And for these reasons, we request the Supreme Court to reverse the lower court's decision. Thank you.
Thank you, Ms. Titan.
May I proceed, Your Honors? Honorable Justices, may it please the Court. My name is Gia Nickdow, and I'll be covering the second issue concerning the non-compete clause. Once again, Your Honors, this is a case about a company that prioritized its comforts and convenience over its most valuable employees' family and faith. Sabrina Katpinteru has the right to work, and based off the three-part test laid by the Supreme Courts of Iowa, BRAT Air's non-compete clause is not enforceable for 4 reasons.
What are the 3-part tests?
The first part is whether or not the clause is necessary to protect the employer's business. The second part is whether it is unreasonably restrictive, and the third test is whether it is prejudicial to public policy. BRAT Air and their non-compete clause fails under all 3 conditions.
What are Sabrina's rights under the second test?
Her rights are specifically relating to the right to work and specifically wanting to work in the CNMI as a pilot. Because this clause is limiting her from flying.
But she
throughout-
was given the opportunity to work, but it's just on Saturdays, so
Your Honor,
she's the one who voluntarily quit.
Your Honor, Sabrina did not voluntarily quit. She was actually terminated by BRAT Air for not showing up
Oh,
on
I
her
see,
shift.
yeah, she was terminated, but, okay.
So in the end, this is a business decision that BRAT Air made and now should reap the consequences of it and not enforcing the clause on Sabrina.
So it's just the right to work under the second test.
The right to work and the right to protect, for the second part, yes, Your Honor. It's just that Sabrina should have the right to work under this, or without enforcing this clause.
But counsel, isn't one of the factors to consider as well is the benefit conferred by BRAT Air to your client? They spent over $30,000 to give her that certification.
Your Honor, even though they bear the cost of the training, it still does not justify restricting Sabrina's right to work. And even if she signed this clause, she could have never anticipated that BRAT Air would not accommodate her religious faith and would even fire her for wanting to remain true to her religious obligations.
And what's
wasn't
your
this-
basis for that statement?
That Sabrina would not be able to fly
Yes.
under the clause.
Yes.
She is not able to fly under the clause because the conditions of the non-compete clause state that regardless of why she was terminated, she cannot work in the entire CNMI for 5 years, which is too restrictive in its geography and its duration. In the case phone connection,
Well, she could still go and work in Guam.
Your Honor, even though she could have moved or she could move off island, that really is not her intent to. And Because she has spent all her years training in the CNMI, all her experience is specialized to the CNMI flights, she should have the right to work here as she chooses to do so.
While in Guam, she does not have to undergo this specialized training.
Your Honor, we realize that, but additionally, the hardship imposed on Sabrina to follow this clause, like having to move to Guam, would be too significant and would be at the minimal benefit of BRAT Air.
Can you talk about the first factor?
Yes, Your Honor. Sabrina's role in the company was strictly operational. She did not have close proximity to customers, nor a peculiar knowledge that provides a means to pirate customers. That was seen
But
in the
isn't
case.
it reasonable to expect that the customers would follow her since she is the only person in the Commonwealth who can fly this route?
Your Honor, we believe that it's not reasonably inferred in the record, because BRAT Air themselves were the ones that terminated her, and any post-termination financial status that BRAT Air has to deal with was solely on their doing and not on Sabrina's. So therefore, restricting her in working in the CNMI would not be reasonable. Sabrina did not also personally reach out to previous customers when she transferred jobs, which is an important factor considered for enforceability in the case Brand Horse. In fact, BRAT Air themselves were the ones that directed customers to Swift Air. Additionally, Sabrina's training was not
But
proprietary.
counsel, wasn't the direction by BRAT Air forwarding the customers to Swift Air is because there is no certified pilot in the CNMI?
Yes, Your Honor, and it's for that reason we argue that it is important to the community that this service is still maintained and that Sabrina should be able to fly it, because BRAT Air themselves realizes that the service of flying to Anatan and Pagan is important, and that's why they direct their own customers to Swift Air.
Why is it
What about
important?
the argument that there is shipping or boat service between Pagan and Anatahan?
Your Honor, even if that is an alternative, it's not an equal alternative, because the deposition stated by Sabrina says that the boat travel would be far more timely and would not be as convenient as the flight services itself.
Why is it important? I guess you're looking at the third factor, right?
Yes, Your
The
Honor.
public interest. Why
Yes.
is it important?
It's important because without Sabrina's services, there is no sustainable, locally available pilot to conveniently transport people from Pagan to Anatahan, and all alternatives are off-island and not accessible to the public.
Well, isn't that contradicted by her own suggestion that her friend, Mr. Sablon, the pilot that's also trained and certified when she went to New Zealand to get her certification, he's available to provide that service. So how is this against public policy?
Your Honor, at this time, Troy Sablon, the alternative pilot, is not employed under the CNMI, any of the CNMI regional flight companies. So therefore, it's not accessible to the public and still makes it prejudicial to them, since there are no alternatives to Sabrina with this flight. Unfortunately,
What is the guidance that we can give the attorneys and the public out there if we decide in your favor? I mean, here we have the airline industry with just one experienced or one capable pilot of flying between the two islands. But let's say we extend it to another industry, for example, a restaurant, maybe a Thai restaurant where there's a Michelin chef there, and that chef decides to quit in 2 days after given notice. So how do we handle that? Because this is going to be a major decision, and it's not only going to affect the airline industry.
Your Honor, because non-compete clauses directly interfere with an employee's right to work, we believe that this case should set precedents that non-compete clauses within the CNMI should be disfavored. Non-compete clauses enforcement should not.
Wholesale disfavored?
It should be disfavored because non-compete clauses should not mean banishment from one's home. And because the CNMI is much smaller in radius compared to a non-compete clause in the States, it would mean banishment from one home. And that
Well, give me a compromised position.
Your Honor,
Because here you have a 5-year ban, right? So what would be the moderate view here?
So, Your Honor, an alternative could have been reached when looking at the case Cedar Valley, because that case does not enforce the non-compete clause to restrict the employee's right to work, but instead to alleviate the financial damages and the investment caused to the company. So that could have been applied in Sabrina's case, since really the concern with BRAT Air is that they bear the cost of training. However, BRAT Air never reached that compromise and instead promptly terminated her after her 10 years of service after missing 1 day.
Counselor, so is the market between Anatahan and Pagan route so small that it can only support one company?
Your Honor, we believe that it could support more companies if applicable. However, within the certain circumstances, Sabrina is the only one with that training, and because that training is the only option, it should not be tampered with in interest of the public.
Well, counsel, in this context of the non-compete clause, it only applies in the CNMI. So couldn't your client get employed out of Guam, and instead of having pilot Sablan be the one flying those routes, she could be the one flying those 3 days, not just Saturdays, or as what she got at Swifties, Tuesday, Thursdays, and Sundays to accommodate her religious belief?
Yes, Your Honor. I believe that's one of the accommodations that Sabrina stated under issue 1.
No, that she
However-
would be the one to be employed out of Guam, not to have Mr. Sablan employed. This is the non-compete clause issue because her employment within the CNMI violates the contract. That's why it's a breach of contract. So my question, and you can answer this, my question is, why is it that to avoid this, Sabrina, your client, be the pilot employed in Guam, but servicing the Natahan Pagan route?
Your Honor, we believe that it would still be too restrictive on Sabrina if she were to work out of Guam. Firstly, because she has expressed an interest in staying in the CNMI, being with her family, and cultivating the lifestyle that she has grown up with. And secondly, we believe that it's still too restrictive because her experience, her 10 years of flying as a pilot have been catered to the CNMI regional flights. So if she were to if she were to move to Guam and be serviced out there, it would still put her at a professional disadvantage that wouldn't be fair to her, and it wouldn't be fair to the public interest that needs to be protected by not enforcing this clause. Your
Thank
Honor,
you.
Ms. McDowell.
Thank you, counsel. You have 2 minutes of rebuttal, so we look forward to it. Okay.
All right.
thank you, Your Honors.
All right. Okay, who's appellee's first counsel?
Mr. De La Cruz?
Good morning, Your Honors, and may it please the court. My name is Christopher De La Cruz, and I, along with my co-counsel Carly De La Cruz, will be representing the appellee BRAT Air. Before
Counsel, don't you think it's too drastic of a measure to just fire Sabrina without, I mean, I would say that the standard employer will probably issue an admonishment. Like if you don't show up a second or third time, as you cited in the case, one of the cases, the employee was given, I think was absent for 10 days, and that's when the termination took place. But here it's just April 11 and then April 15 termination. Don't you think that's a drastic step?
Your Honor, just to clarify, you're asking me if it was drastic that BRAT Air terminated her after
Correct.
only-
Yes, that's my question.
Your Honors, it wasn't drastic because Sabrina herself stated that she would not be taking Saturday flights for the next 6 months. With 4 Saturdays for every month, that's approximately 24 missed Saturday flights.
Yeah, well, Counselor, it's been 6 months since she was terminated, and your company still hasn't hired a replacement. So, but you know, by now you would have her back.
Your Honor, my BRAT Air lacks the financial resources and the human resources to hire and retrain another pilot.
So,
With
if your client does not replace Sabrina, wouldn't that be equivalent to just abandoning that route, and then therefore somebody else can pick it up?
Such as Swift Air.
Your Honor, you're asking me if they lose Sabrina, then they have no choice but for Swift Air, their competitor, to now gain control over the route.
So, your first argument down at the Superior Court was that you cannot afford a pilot to be trained. So by not having trained another pilot, you've abandoned that route.
Yes, Your Honor. As mentioned, BRAT Air doesn't have the resources to train another pilot.
But
and-
didn't Ms. Katpinteru give you notice and an opportunity to temporarily hire pilot Sablan out of Guam, who was certified and is able to handle just that 1 day out of her 3 day per week? And she's been working for the company for 10 years.
Your Honor, I must firstly address that even though Troy Sablan might have the same certifications that Sabrina did have, he lacked the necessary experience to navigate through the dangerous topography of the Pagan-Onatan route, to land on limited runways, and to also avoid volcanic ash and endangered bird species.
Well, I'm sure that's something that could have been accommodated on the Tuesdays and Thursdays when Ms. Katpinteru was available to guide him and say, on Saturday, you're going to be handling this, but let's go Tuesday, Thursday, so you can actually see what I do. It's that accommodation type of cost. That was not considered, was it?
Yes, Your Honor. However, they would still make no profit over 6 months on their Saturday flights if they were to hire Troy Sablan.
But the result of you terminating Ms. Katpinteru is that you went from profit on Tuesday, profit on Thursday, break even on Saturday, if you hire Troy, to just zero income altogether. And it's been 6 months. So how does that fare out with public health and safety?
Your Honor, the reason my client, BRAT Air, had to terminate Sabrina for missing only her Saturday flights was because they invested $30,000 for her to receive the specialized training so that she could fly the Tuesday, Thursday, and Saturday route that they were contractually obligated to fly for. They did not pay Sabrina for Sabrina's training so that she would only fly on Tuesdays.
But
and
counsel,
Thursdays.
what was that case that you cited involving the unions?
I believe, Your Honor, you are referring to TWA versus Hardison. However, I did not refer to.
Yes.
any-
Was there any accommodation effort made by BRAT here? Because in TWA case, the union wasn't even enforced or was asked whether it was okay to do some shift swapping. But here, I don't think there was an effort by BRAT, right? To check with post-load whether, well, I can think of one accommodation here, since the confirmation classes will be held Saturday evenings, correct?
Yes.
Why can't the flight leave at 5 a.m. as an accommodation made by BRAT, or why can't it leave Friday night so that Sabrina can attend her Saturday evening classes? Was there any effort from BRAT?
Yes, Your Honor. There was substantial effort from BRAT Air, especially given the limited amount of time that Sabrina provided them, which was only 4 days before her next Saturday flight.
Was there any contact with standalone?
With Your Honor, you mean post
Oh,
alone?
post-alone. Same
Yes.
thing.
Yes, Your Honor. General Manager Billy Ishii, in Sabrina's own deposition, stated that they reviewed the financial costs of the accommodation Sabrina did present to them. That would include
No,
the-
but did the executive of BRAT contact the executive of Post-Alone, asking whether early Saturday morning or Sunday flights can be done?
Your Honor, that specific issue is beyond the record. However, I will say that even if assuming General Manager did, I don't believe that given the limited amount of time Sabrina provided, that they could instantly revise this years-long contract.
Because
they had
that
with
was what
Post-Alone.
exactly happened in TWA. There was no effort. The union was not contacted, right? The district court, or the appellate court in that case, the lower court, made that mistake in their findings of fact, and that was why it was reversed and remanded.
Yes, Your Honor. In Hardison, that is correct. However, BRAT Air did make efforts to accommodate for Sabrina.
What was the accommodation?
Sorry, Your Honor, just to clarify, they did assess the accommodations that were possible, but none were possible without incurring undue hardship on BRAT Air.
And you're saying the undue hardship is on the de minimis standard, going back to the first question, I know, but we're talking about the anti-compete clause here, right?
Yes, Your Honor.
Counselor, so,
First
Sorry.
issue.
I'm sorry.
Yeah.
If we are to adopt the substantial increased cost standard, how does that favor your case?
Yes, Your Honor. I understand that the lower court applied the de minimis test, but for your question, BRAT Air would still fulfill their burden to prove undue hardship under the substantial increased cost test. Sabrina's
How?
Sabrina's first accommodation, specifically to rehire and retrain another pilot, would have costed BRAT Air a significant cost of $25,000.
What if Sabrina conducts the training herself, company time?
Your Honor, you were asking about the time, like the experience Sabrina has
Yes.
gained.
She's the only one in the Commonwealth that can do it.
Your Honor, could you please clarify exactly what you're asking?
So it would cost your company less than $20,000 to train another pilot because Sabrina can do it, right? She's certified. She's been flying this route for 9 years.
Yes, Your Honor, but the problem at hand is Sabrina is requesting to not fly on Saturdays for the next 6 months and to revise the contractual obligation they have to post a loan, which, if they were to alter the flight schedule, BRAT Air would have to significantly discount the cost of each flight that post
But
loan
that's a
pays for.
hypothetical, and that's exactly what one of the cases said. Now, you can't just say, oh, this is going to happen. It has to be more practical than that, right? What was that hypothetical? Anyway, I want to just touch on something else here. Don't you think that it was a risk that BRAT took in not getting an alternate pilot? Sabrina was working for BRAT for 10 years, and, you know, Sabrina is not going to be there for her lifetime. So don't you think that this was a risk that BRAT took?
Your Honor, I know my time has ended, but could I
Answer the question.
Your Honor, as mentioned, BRAT Air lacks the financial resources to rehire and retrain another pilot. Of course, my client would love to have as many pilots to fly the Anatan Pagan route, but they simply lack the finances and the human resources to train another pilot like Sabrina.
I think the record said that they made profits over the past 10 years from Sabrina. Okay,
Your Honor.
thank you, counsel.
Thank you, Your Honor.
You may proceed.
Your Honors, and may it please the Court, my name is Carly De La Cruz, and along with my co-counsel, Christopher De La Cruz, I represent the appellee, BRAT Air. My argument will consist of 3 points. First, that the non-compete was necessary to protect the business of BRAT Air, that the non-compete clause was not unreasonably restrictive of Sabrina's...
Counsel, in the cases that you cited, what was, I mean, they had to consider temporal and geographic factors, right? So what was the temporal factor in those cases that you cited?
I'm sorry, Your Honor, could you clarify?
The temporal, the timeline for not to compete, the number of years in the
Ti-
cases that you cited.
Well, Your Honor, while it is true that in most cases, the duration of the non-compete would be 2 to 3 years. It is cited that in Phone Connection v. Harps, it cited Rasmussen that stated that the Court of Appeals found in an examination of recent Iowa cases.
In the phone connection case, what was the time limit?
In the phone connection case, the time limit was 2 years.
3 years?
2 years.
2 years. And in most of those cases that you cited, it was on the range from 90 days all the way to 5 years. But I think there was only one case with 5 years, like the BRAT case today, 5 years. Do you think 5 years is too long for a non-compete clause?
No, Your Honor, I don't think that 5 years is too long. As I was about to say, that in Rasmussen, in recent Iowa cases, they found that the duration of a restrictive covenant typically ranged from 2 to 3 years. However, it said that restrictive employment covenants beyond 5 years.
So it is okay for BRAT to tell Sabrina that, Sabrina, you cannot work in the CNMI for 5 years as a pilot.
Your Honor, the reason why we are asking Sabrina to not work for 5 years is because we need to make sure, ensure the public safety that because as Sabrina had worked for BRAT Air for 10 years,
But you could train another pilot.
while we could train another pilot, Your Honor, they would not have the same experience that Sabrina had had for her 10 years.
It takes only 2 weeks to train and certify a pilot to run that route.
Your Honor, while certifications are one thing and experience is another thing, it would, as Sabrina stated in her deposition, it would be extremely hard to be able to get through the endangered birds, the ash from the volcanic eruptions, and the small landing strip. And also in her deposition, she stated that there's no other route like Anatahan and Pagan, and that it is extremely difficult to fly this route.
Right, and that's the two weeks training to fly that route. 2 weeks, Counselor.
While it is 2 weeks to get the certifications that Troy Sablon could have gotten, he does not have the same experience that Sabrina would have had. Now to the first point of why.
Counsel, I asked earlier about other industries that may be affected by our decision today, like the restaurant industry. To tell a chef that you can't cook or work at another restaurant for 5 years, don't you think that's, again, the word drastic? 5 years of unemployment in the field that you love.
No, Your Honor, because while Sabrina could not have worked in the CNMI for 5 years, she had other places to go to, such as Guam. Now to the first point of why the non-compete clause was necessary to protect BRAT Air. Much like in Cedar Valley Med Specialist v. Wright, when Sabrina left BRAT Air to compete
I'm having problems with that because the first factor is for the reason, it has to be reasonable, right? For the
Yes.
protection of BRAT's business. But don't you think that BRAT here was unreasonable in not trying to protect its own interests, for instance, as Justice Inos said, to train another person for 2 weeks? Or, don't you think that it's a fault here also for not acting within the past 10 years in preparation for Sabrina's departure or Sabrina's illness? Because it looks like this is a one-man operation in fact.
Firstly, Your Honor, I would just like to say that every reasonable employer would have terminated Sabrina for not showing up to work. The contract was terminated,
Well,
yes.
she missed only 1 day of work, then she got terminated, right?
Yes, Your Honor. However,
And for 6 months, Swift Air has been flying to Pagan and Anatahan, and I don't want to say tree huggers, but the conservative group, they weren't complaining about the Sunday flight over Saturday.
yes, Your Honor, but the fact we have to take into consideration is that the contract with BRAT and Post Alone was different from BRAT and Swift Air. The contract.
Right, so you've went from reaching 1 day a week of travel to a completely zero flight. That's your choice, right? I want to ask you a question about factor 3, prejudicial to the public interest. Do you think that the boat ride would be sufficient alternative to the airline?
Yes, Your Honor.
Do you know that the distance between Anatahan to Pagan is the same distance as it is from Saipan to Guam? You expect passengers to swallow that hard trip?
While it is a longer trip, Your Honor, BRAT Air has the protection of the public safety in mind. While it is a longer trip, if BRAT Air were to
It's
hire,
an 8-hour trip on a boat.
while BRAT Air if they were to hire Troy Sablon, like I've said, he would not have had enough experience to be able to fly this route with the birds, the ash from the volcanic eruptions, and the small landing strip.
And let me ask you this other aspect of this non-complete clause. Doesn't your argument that BRAT spent a lot of money to train Sabrina, and this was in the beginning. So she's been employed for 10 years, she's been flying this route for 8 years, and the non-compete clause restricts her for the entire CNMI. Why should the clause be enforceable for all of the CNMI if it was really focused on an Anatahan and Pagan route? What if it were any other part of the CNMI?
Well, Your Honor, while it is true that we could just modify this case to make it so that Sabrina cannot fly the Anatahan and Pagan route, if the court decides that the non-compete clause can be modified in this case, then all will be challenged, and this will cause everyone to come to run to court. This will result in a heavy burden on the judicial system. Contracts will not be worth the paper they are printed on.
Okay, what was that case you cited where the court did modify, remanded the case, and said, employer, you can just limit to parts of Iowa and parts of Minnesota. So I guess that's the geographic factor, right? As Chief Judge Mangloña asked, can we limit it, can we cut also the geographic application here?
Yes, Your Honor, we can.
What was that case that you cited?
Your Honor, I don't think I cited that case. I believe the opposing counsel cited that, but I believe that it was phone connection v. Harps, and if I may, Your Honor, may I briefly conclude?
Go ahead.
It is for these foregoing reasons that we ask the court to uphold the non-compete clause.
So we can carve out parts of the CNMI so that Sabrina can just not work in the Anatahan Pagan area, but it's okay to work in Saipan, Tinian, and Rhoda,
Yes, Your Honor.
applying phone connection.
Yes, may I briefly conclude?
Okay, thank you.
It is for these foregoing reasons that we respectively ask the court to uphold the non-compete clauses. And if there are no further questions, thank you, Your Honors.
All right.
Thank you.
Thank you, counsel. Yeah, we have, what's the time?
2 minutes.
2 minutes? All right.
Your Honors, in response to the appellee's claims, they state that the company would make no profit, but again, we reiterate that there were no analysis or statistics shown, and thus this is an assumption. Under Brown versus General Motors, assumptions, hypotheticals, or theoreticals are not enough to prove undue hardship.
What is the case?
Brown versus General Motors. Second, the appellee only covered one of 3 possible accommodations. BRAT Air could hire Troy Sablon, and Justice Marshall's dissent along with Groff show that hiring a temporary employee is a reasonable accommodation. Additionally, Post alone was able to actually change their schedule to Sunday as shown in the last page of Sabrina's deposition, Exhibit C. Third,
In our graph, the Supreme Court mentioned that the heightened standard, we have to take a look at, we have to be fact specific. There has to be a fact specific inquiry. And what are those inquiries that the lower court should ask?
firstly, the court must consider Sabrina's occupation and the different factors.
No,
in
on
her-
the business, because it's the nature of the business, right? The size of the business. Here, Brown is really not a large business. No, and you remember the University of Kentucky case? Now, the office only has 3 employees, director, and the front desk person and the researcher. So isn't that similar to this case, where
Yes,
it's
sir.
only Sabrina?
Yes, Chief Justice Mangloña, I would like to distinguish that case on a few different grounds. Firstly, DeVore's job required full-time employment, and her suggestion of hiring a temporary temporary employee was not enough to cover her shift. On the contrary, Sabrina's suggestion of hiring a temporary pilot, Troy Sablon,
But
would be
in DeVore also, there was a suggestion of why don't the employee go remote?
I'm sorry, Your Honor, may you
The
rephrase
employee
that
wanted that accommodation to work remotely.
Your Honor, my time has elapsed. May I
No,
briefly
please answer.
answer this question? Yes, that DeVore made that suggestion of remotely working. However, that was not a reasonable accommodation because her job required full-time physical presence. Unlike this case, Sabrina is at least able to work on Tuesday and Thursdays, and maybe potentially even Sundays if BRAT Air was to make
Thank you,
that.
Counsel. Your
Thank you.
time is up. Oh, we have a 2-minute rebuttal also?
3 minutes.
Your Honors, opposing counsel attempts to say that BRAT Air could have simply hired Troy Sablon as a reasonable accommodation. However, as mentioned, BRAT Air lacks the financial resources to make up for the loss of profits that they would incur by hiring Troy Sablon.
But by hiring Troy, you'll be breaking even.
Yes, Your Honor, but as I mentioned previously, they would be
You will not
losing. Your Honor, they wouldn't be losing money specifically from hiring Troy, but they would lose the return on investment they made into Sabrina herself.
Well, she's been working under that license for 8 years. I think you would have recovered all that profit by now, wouldn't you say?
Yes, Your Honor, but the concept that the opposing counsel is presenting is that BRAT Air has to lose the potential $30,000 costs by hiring Troy Sablon to replace Sabrina for her Saturday flights.
But Troy Sablon's already certified. He was with Sabrina during her initial training, so that is why she suggested him as an option to just cover the Saturday route when she's not available if there is no other accommodations. Isn't that the case?
Your Honor, I understand that Troy Sablon might have the same certifications, but as I previously mentioned, he doesn't have the experience. Likewise, Your Honors, the opposing counsel attempts to say that the non-compete was, I believe, let me look at the case, unreasonable because of the scope. However, the geographical scope is only one factor that should be taken into account. It's also accessibility. Other clients, like Post Alone, who would like to travel to Anatan and Pagan could still, like Sabrina admitted in her deposition, take boats as an alternative method of travel. I do understand.
Counsel,
Yes, Your Honor.
we have to review the trial court's decision. And do you think that analysis was sufficient, though, on public safety and health concerns? What's the public safety issue here?
Your Honor, the specific public safety issue here is that because Sabrina is the only pilot with not only the certifications, but the experience to fly through, as I mentioned, difficult topography, volcanic ash, and endangered birds that pose not only a threat to Sabrina herself, but the lives of the researchers aboard.
So I thought it's the Pagan Sea, that was the public safety. I was trying to understand this BRAT case and the Bill case. In the Bill case, it made sense, because there has to be 24/7 police protection. But here, what is the public safety concern with the release of the Pagan Sea to the wild?
The specific public safety issue, Your Honor, is that Sabrina is the only qualified pilot. There is no other pilot. who
So it's
could-
a pilot instead of the, okay.
Yes, but also, just to clarify, Your Honor, may I finish?
Yes.
In Beetle versus Tampa, they concluded that organizations associated with public health and safety should adopt the greater de minimis test. And likewise, Your Honor, an airline's primary concern is safety and not profits. And we see this because BRAT Air, instead of continuing to offer flights to Anatan and Pagan, willfully directed
But don't
clients.
you think BRAT Air made a good return of its investment with Sabrina's $30,000 training over, Sabrina was with BRAT, right, for 10 years?
Your Honor, I must again give him.
So that was a good return of investment, having an employee there for 10 years?
Your Honor, that's a good question. However, it wasn't, Your Honor, asking if, because they kept her for so long, they likely made a return on investment already, just to clarify.
Okay, thank you, counsel.
Thank you, Your Honor.
Thank you, Mr. De La Cruz. Is it complete?
Okay, thank you, counsel, for the appellant and appellee. The court will take this matter under advisement, and we will come up with a decision in a few minutes. What we're going to do here now is we're going to go back to the deliberation room and deliberate, consider the arguments of counsel, and make a decision. We'll be back in about 5 to 10 minutes.
This court is now adjourned.
Because usually they give a written what they're gonna make. Huh?
Okay. So a little bit overwhelmed under pressure.
That's good. You had an opportunity to practice with, you're dealing with real Supreme Court.
I'm one of the.
Took it really hard, had to sit out this round.
It just tells them how to.
Yes. On, I don't know what. 12. 12 here. Yes, we shall start at 12 o'clock. Support the youth, James. Oh.
That's how close it is. So congratulations.
Okay.
Well done.
Hold on.
Okay.
Justice,
So-
okay, have a safe flight. Thank you
Excuse
for,
myself, thank you.
so,
You probably noticed that I didn't ask questions regarding the experience of a pilot.
okay,
That is very important.
thank you, Justice. Justice Enos was very instrumental in putting, in assisting with this program, so our thanks to him, Chief Judge.
My comment is similar to Justice Enos. Just by a hairline, it's obvious why you four are here in the competition for the championship round. And so I commend you all. I mean, you're in high school and you're able to gather the facts. I read the package, and having that transcript and the like to be memorized in that fashion, that's pretty impressive. You were able to stand your ground, just to be able to listen and actually hear the answer. And I'm sorry for the somewhat rude panel here that's kind of jumping over each other, because we're eager to get the question and we're almost thinking it out. As I think at one point I even finished a question for the other justice, because I wanted to ask it, but he started. So you guys, all four of you, did a wonderful job in that regard. The fact that you're dealt with the cards you're dealt with, meaning the case law and the facts, and yet you stood your ground based on what you can reasonably argue within the rules. I know there was one part of, well, that's not a part of the fact pattern. I was thinking, yep, that's the way to do it. Is it tells me that you read and you understand your case. So well done. Much, much better in some cases. For some attorneys, I'll say that. So you're already ahead of the game. Great job.
Yeah. You know, in a real case, appellate case, where's Robbie, Mr. Glasses here? He argued here a lot of times, but we're not that rude. I don't think we're that rude with him. Yeah. But here, we just jumped in, right? We didn't give you a chance to even lay out the factual background.
Yeah, he was mean. He cut you off right before you
Yes, we
started
cut you off.
your numbers.
And and that was deliberate, because this is a preparation for the competition at Yale or wherever
That's true.
the winners are going. But your composure was just remarkable. You understood the substance of, and I asked what case was that about, and you reminded me of the case. So, it's obvious that you read those cases or summaries of those cases. You folks were just remarkable. It's hard to believe that you're high school students. The questions from the three of us, there were difficult questions, but I hope that when you go home and you're analytical, you notice that your analytical ability the past 2 months have really increased tremendously because of the reading materials and how you present yourself during practice in your appellate arguments. It's just remarkable, and best of luck.
Yeah. Did it feel like this all lasted too long for you, or was it too fast? Too fast, right? That's what I was going to suggest. Maybe next time give us, because we all wanted to jump in, as you could see. Many a times I was about to start something and one of the other justices jumped in first. So we obviously wanted to engage you because we wanted you to respond, and you did a great job in doing that. So maybe that's something we can recommend.
Yeah. In an appellate argument, in the real world, we give 25 minutes per side to argue. You only had 10. That's not enough to give you complete arguments, but 25. Do you have any questions while we're here? Okay. By the way, Chief Justice Castro is not here. He's under the weather, but he wished that, I think he's watching online.
Where's the
So he's sick the past couple of days. Okay. Any questions that you may want to ask the judges? You sure? Now's your chance.
How many seniors of the four before us? 2 seniors? How many juniors? Sophomore? Oh my gosh.
You two
This
are
school's going to be
sophomores?
busy for the next couple of years.
Amazing.
You went up against sophomores.
Okay. Are we
That's
ready?
impressive.
Not yet, Your Honor.
Not yet?
12 o'clock. Is it ceremony?
I'm sorry.
12 is a award ceremony.
Oh, okay. So we're going to announce it.
Yeah, but if we can if the tabulation is done, let's just,
We're gonna announce it.
No, tabulation is going to take probably another 15 minutes minimum.
all right. So we'll take a few minutes recess.
Okay.
Okay. Thank you so much.
Thank you.
Hi, everyone. Welcome back. We are going to begin with our awards ceremony. I just want to start again. This is going to be a common theme. I want to give everybody a round of applause for your performance. We know best of all that this has been a huge feat for everybody to do, especially if you were competing yesterday and not today. Thank you for coming back. Thank you for attending the awards ceremony. I promise it is worth your time to be here once again. First, we wanted to begin with recognizing some of our special guests in the audience. So first, from the Public School System Federal Programs Office, we have Militia San Nicolas. This competition has been funded at least in part by federal programs, so we want to thank her for her support and providing assistance with all of our needs throughout the semester. We also have the Marianas High School principal, Melanie Urdial. Thank you as well for coming out and supporting all of these students. MHS, as you know, is about half of all of the competitors this year, so support from all of the schools has been instrumental in the success of this program as well. And we also have the president of Mount Carmel School, John Blanco. Okay, that's enough for the introductions. I'm sure that you know everybody else who is standing up. My name is Paige Lehman. I'm the law clerk for Justice Mangloña. Next to me, we have Isabel Castle. She's the law clerk for Chief Justice Castro. And finally, we have, in not a robe, we have Nathan Ford, who's the law clerk for Justice Barry Enos. Yes, Militia, would you like to come up and join us for the award ceremony? If not, you can stay right there, but as an equal partner. Yeah, okay, you don't have a choice. And so now we will be giving the certificates of completion by school.
So we're going to begin giving out the certificates of completion. I know a lot of different events give out a certificate at the end of it, but I want to just highlight the value of this certificate of completion, in my humble opinion. This certificate of completion reflects several months of hard work from each of these students. We compiled a case library, and that is a list of court decisions ranging from state, district courts, courts of appeals, Supreme Courts, federal courts, federal district courts, federal courts of appeal, and even the United States Supreme Court. These are things that people usually read for the first time when they enter law school, on their first day of law school. We compiled a list of about 16 cases total, several hundred pages, as well as legal deposition and many other things that our students have to read. We have students ranging from the ages of 14 to 17 here, and they all did a phenomenal job of not just reading and understanding, but then adapting that into legal arguments like you saw yesterday and today. So this certificate of completion reflects that that you all now are essentially at the caliber of law students, and the rest of your life is going to be much easier for you. So beginning with Marianas High School, when I call your name, please come up, accept your certificate, and then wait up here, and we'll take a picture afterwards. So beginning, Denise Fernando, Savannah Flores, Montre Germantz, Grant Lee, Kelly Leanne, Stephen Leanne, Francis Lichta, Sarah Lim, Gia Nickdow, Branred Pamantuan, Yejin Son, Julia Taitano, Ricky Tang, and Jenny Zhang. Slide this way a little bit. I'm so sorry. Can we get Stephen Woodruff up here as well, if he's not already up here? And Principal Melanie, if you would also like to come up. Okay, one last round of applause. Congratulations, everybody. All right, next from Saipan International School. Oh, sorry. From Mount Carmel High School, we have Carly Dela Cruz and Christopher Dela Cruz. And Mr. Blanco, Mr. Glass, and Mr. Tyrone, if you'd like to join us up here. And anyone else from Mount Carmel who I missed. I apologize. Oh, Mr. Corsiani, sorry. All right, and finally from Saipan International School, we have Asa Baki, Jinian Felix Choi, Leah Kim, Scarlett Kim, Kyle Kramer, Charlie Lee, Ava Lizunova, Celine Park, Irene Park, Victor Nash Santos, Libby Tom, Pu Wong, Jackie Zen, and Zihao Michael Zhou. And also Miss Stasha Phoenix. Congratulations. Go.
You want to hit the, oh, you might have to hit it twice for the next.
All right, congratulations to everyone. It's such a big accomplishment. We're very proud of you all. We are going to be issuing our first award, which is Best Brief. Students were tasked to write a 3 to 5 page brief on their respective issue to participate in the competition. Your briefs were judged blindly by the tournament organizers, and we picked the most persuasive, unique arguments, as well as case law to support the position. This brief will be given to Julia Taitano and Gia McDowell from Marianas High School.
Okay, we are moving on to the individual awards section. This is the honorable mention for oral advocate. So this award, anybody who competed in the preliminary rounds but did not move on to the competition today is eligible to receive this award. There are two awardees. The first is the top appellant and the second is the top appellee. So this is the highest individual score as given by all of the justices in all of the rounds. So this is your total out of 600 possible points. Of course, you don't know the totals, but this is, I promise, the top appellant. So our top appellant is Kyle Kramer. That is Saipan International School. And then our top appellee is going to be Stephen Liam from Marianas High School. Can I have our two coaches from SIS and MHS please join? So, Stasha and Steven, can you...
All right. Our next award is for the Best Oral Advocate. This is for the Best Individual Appellant Attorney and the Best Individual Appellee Attorney who scored the highest across all three rounds, preliminary, semifinal, and final. So for the appellant, Julia Taitano. And for the appellee, Christopher Dela Cruz from Mangloña High School. Yeah, sorry. And could the coaches from MHS and MCS please join us for a photo?
our next award is recognizing the semifinalists. We would like to recognize each competitor from the 2 semifinalist teams who did not advance to the championship round. Congratulations for your hard work. Scarlett Kim and Irene Park from Saipan International School, as well as Jenny Zhang and Yejin Son from Marianas High. You both participated very well. You should be extremely proud of yourselves. Congratulations. Coaches, would you like to come up as well?
Okay, and this is the moment you've all been waiting for. The finalist team is the team that has placed second in the round. They have come in second in our championship. That team is from Mount Carmel School, Christopher and Carly De La Cruz. And if we can have the coaches from Mount Carmel join them as well. And if we can have our finalists just move off to the side a little bit while we have our championship announcement, and then we will take a picture with all of the championship round participants. That leaves our champions as Katpinteru and Gia Nickdow of Marianas High School. If we can have Coach Stephen Woodruff join us once again. We will take a picture with our individual trophies, and then we will award Lady Justicia the perpetual trophy to Marianas High School for the second year. Okay, and if we can have Mount Carmel join us back for the photo. Yes. And if our 4 competitors can join us at the top of the bench. Hi, where do you go? So you can go all the way around. Julia, sorry. Oh, Judy. So all coaches come back in for the photo. We're going to stand on the floor and let them rise to the top.
Just some last words. We are assured of one team to go to Yale University, but we're going to try to ask Yale whether we can send our second place team. It's not sure yet, but that's up to the school to decide. And of course, funding is always an issue. So we will be in contact with Yale if that's fine with the second place team. So we're going to have a meeting in the back, just for a few minutes if it's okay. We're going to have a meeting in the back in the deliberation. Oh, yes, yes.
Okay, and the very last event, if we can have our champions remain up at the front area here, we will be awarding Lady Justicia. Sorry, we have the big display.
Just wait till I've seen your Yeah.
So we need. So we need MHS Principal Erdial to return if she is still in the area. Oh, so sorry. And Julia and Gia, please pick up your trophy. It's quite heavy. Yes, and now can we have all of MHS? All of Mariana's High School students, supporters, please join us for a photo. One more photo, and then we're done. This is with MHS.
Good to have it.
This concludes our ceremony for the day. If you are one of the champion or finalist teams, we ask that you please stay back. Everybody else, you are free. There is still snacks in the assembly hall. Please make sure to remove all of your belongings.
Hold on, before you all go, I would just like to say thank you all once again for making our second annual Moot Court competition very successful. If you're not a senior, please come back next year. You all did very well. You're going to do great next year. And if you are a senior, good luck in all your endeavors.